There is a moment in every courtroom, a quiet, almost invisible moment, when a lie enters the room. You can't always see it, you can't always hear it, but if you've spent enough time in these places, you learn to feel it, like a change in air pressure, like something slightly off in the way a person holds their breath before they speak. I've been covering legal proceedings, courtroom drama, and high-profile cases for over a decade. I've watched brilliant lawyers and broken ones. I've seen judges who commanded rooms with a single glance and judges who let chaos rule. And in all that time, one thing has remained absolutely constant. The truth has a way of surviving, no matter how carefully a lie is dressed, no matter how polished the voice that delivers it, no matter how powerful the person speaking. The story I'm about to tell you is one of the most striking examples I've ever encountered. A lawyer at the height of his career. A courtroom he believed he owned. A judge he believed he could fool. And one single document, already in the system, already logged, already sealed, that would reduce everything he'd built to dust. This is not a story about one bad moment. It's a story about a man who had been getting away with things for so long, he stopped believing consequences were real. That kind of person is always the most dangerous and the most satisfying to watch fall. His name was Gerald Ashford, and in the legal circles of the city, that name carried weight. Not the cautious, earned weight of a man who built his reputation slowly. Ashford's weight was the louder kind, the kind that arrives through aggressive wins, strategic connections, and a personality that could fill a courtroom the moment he walked through the door. He was tall, silver-haired, with a jaw that looked carved for authority. He wore suits that cost more than most people's monthly rent, and he moved through legal spaces with the ease of someone who had never once been told no and believed he never would be. He had built his career over 22 years, starting in small civil disputes before pivoting to high-stakes corporate litigation. That pivot had made him rich. It had also made him selective. Gerald Ashford did not take cases he wasn't confident he could win. And over time, that record of victories had inflated into something more dangerous than confidence. It had become arrogance, the kind that doesn't acknowledge its own existence. His assistants knew it. The junior partners at his firm knew it. The opposing counsel who had faced him across courtroom floors knew it. There was a running joke among legal professionals in the district. You'd rather face almost anyone else. Not because Ashford was unbeatable, but because of what the experience felt like. He was condescending in his objections. He interrupted with the timing of someone who had rehearsed how to undermine. He smiled at moments designed to make the other side feel small. But none of that was illegal. Arrogance, unfortunately, is not a crime. What he did in that courtroom, however, was. The case itself was a corporate liability dispute. A mid-sized company, we'll call them Meridian Group, was being sued by a former contractor named Daniel Osei. Osei was a structural consultant who claimed Meridian had used his proprietary analysis methodology in a major infrastructure project without credit, without compensation, and without ever acknowledging his contribution. Meridian denied it. They had retained Gerald Ashford to make sure that denial held up. On paper, it looked like a manageable case. Osei had documentation of his work, but Meridian's legal team argued the methodology was standard practice in the field. Nothing proprietary, nothing exclusive, nothing that could be fairly owned by one individual consultant. Ashford was confident, more than confident. He was dismissive. In a recorded pretrial meeting, he was heard referring to Osei's case as the kind of thing people file when they need money and a story to put around it. Daniel Osei was 53 years old. He had spent 30 years building his career in structural consultation, working mostly on public interest infrastructure projects in underserved areas. He was not wealthy. He was not connected. He had taken this case not because anyone told him it was winnable, but because he believed he was right. His daughter had helped him organize his documentation. His wife had taken extra shifts to keep them stable during the proceedings. He was the kind of person who shows up every day, quiet, prepared, precise. He did not make grand speeches. He did not perform. He simply brought his evidence, believed in the process, and waited. The first few hearings went broadly as expected. Ashford was in full command, articulate, aggressive in cross-examination, skilled at pulling threads that made even clear evidence seem ambiguous. He challenged Osei's consulting contracts, questioned the specificity of his methodology, and built a picture of a man with a grievance and a loose interpretation of ownership. The judge presiding was the Honorable Patricia Mbeki. She had been on the bench for 16 years. She was known for two things: exceptional patience and an absolute intolerance for dishonesty. She had a way of listening that made some lawyers visibly uncomfortable, not because she was hostile, but because she was thorough. She missed nothing. She noted everything. And in a courtroom, that kind of attention is its own kind of power. Ashford had appeared before her twice before. He had won both times, which may have led him to believe he had her measure. That assumption would prove to be expensive. The critical moment came on the fourth day of proceedings. The case had reached the point of examining a specific timeline, specifically when Meridian Group's internal team had begun developing what they called their proprietary methodology, and whether that timeline preceded or followed Osei's consultation period. This was the hinge of the entire case. If Meridian's development predated Osei's involvement, the case fell apart. If it followed, the foundation of Osei's claim was solid. Ashford stood and addressed the court with the ease of a man who knew exactly what he was doing. He stated, clearly and without hesitation, that Meridian Group had begun internal development of this methodology 18 months before Daniel Osei was ever brought in as a consultant. He cited an internal project log. He cited a memo. He cited time-stamped communications from Meridian's project team. And he stated, looked directly at Judge Mbeki and stated that no documentation existed that contradicted this timeline. The room took it in. Osei's attorney, a younger lawyer named Sadie Carpenter, who had been working this case with clear moral conviction, made a note. She didn't react loudly. She just wrote something down, quietly, and continued listening. Judge Mbeki looked at Ashford for a moment. "Counsel, are you representing to this court that no documentation exists that places Mr. Osei's involvement prior to the start of Meridian's internal development?" Ashford's answer was immediate, clean, confident. "That is correct, Your Honor. No such documentation exists within the scope of this case." He was lying, not exaggerating, not misremembering, not offering a generous interpretation of ambiguous facts. He was lying, and he knew it, and he had calculated, as he had likely calculated many times before, that he would not be caught. The document he was lying about had been filed. It had been submitted as part of a discovery package 7 weeks earlier. It had been logged, stamped, and entered into the court record. It was a project initiation email from Meridian's own internal correspondence, sent by a senior manager to Daniel Osei, formally onboarding him as lead structural consultant on the project. The timestamp on that email predated Meridian's claimed start of independent development by more than 3 months. 3 months. The email didn't just complicate Ashford's timeline, it demolished it. Sadie Carpenter had found it buried in the discovery documents, not hidden deliberately, it seemed, but buried beneath the volume of material that large corporate legal teams often use to obscure what they don't want seen. She had read every page. She had built her case around that document, and she had waited, deliberately, strategically, with the patience of someone who understood that timing is everything, for exactly this moment. She rose. Her voice was steady. "Your Honor, with the court's permission, I'd like to reference Exhibit 47 from the discovery filing dated." She gave the exact date, which I believe directly contradicts counsel's representation to this court. The document was entered. The email was read. The timestamp was clear. The silence that followed was not the comfortable kind. It was the kind that happens when something irreversible occurs, when a thing is out in the room and cannot be put back. Ashford's expression did not collapse. Men like Ashford have spent too long in performance to let their face betray them in real time. But there was a shift, a tightening, a recalibration, visible to anyone watching closely. He attempted a redirect. He suggested the document may have been mischaracterized in discovery. He offered an alternative framing of what the email's language actually meant. Judge Mbeki stopped him. Not loudly. She didn't need to be loud. She said, with the same measured calm she had maintained throughout, "Counsel, I have read Exhibit 47. I would like you to explain, specifically, how your prior statement to this court, that no documentation existed placing Mr. Osei's involvement prior to Meridian's internal development, is consistent with this document, which appears to be exactly that." There was no good answer. There was no clever redirect. There was no exit that preserved what he had just claimed. Ashford attempted one more reframe. It didn't land. It couldn't. The judge had the document. She had his words. And she had 16 years of watching people in exactly this position. She called a recess. What happened in that recess, and in the proceedings that followed, is what this story is really about. Because the lie had already been exposed, but its consequences were still coming. During the recess, sources familiar with the proceedings later described the scene in the hallway outside the courtroom. Ashford's junior associates stood apart from him, the kind of physical distance that says everything without words. The client representative from Meridian, who had attended most of the hearings, was on a phone call, voice low, face strained. Ashford himself stood near the windows, jacket straightened, expression controlled. Daniel Osei sat on a bench in the hallway with his daughter, who had taken a day off work to attend this hearing. He didn't know yet exactly what he had just witnessed. He understood something had shifted. His attorney came out and spoke to him quietly. Whatever she said made him close his eyes for a moment. Just a moment. Then he opened them and nodded, slowly. He had waited 30 years to be taken seriously. He had spent his career doing careful, honest work in fields that didn't always reward careful, honest people. He had taken this case because the alternative, silence, acceptance, moving on as if nothing had happened, felt like a betrayal of everything he had tried to build. And now, in a hallway outside a courtroom, something was happening that he had not been entirely sure was still possible. When proceedings resumed, Judge Mbeki's tone had changed. Not in volume, she had always been measured, but in weight. There was a gravity to what came next that everyone in the room could feel. She addressed Ashford directly. She outlined, with precise and careful language, the sequence of events. His statement to the court, the document that refuted it, the fact that the document had been in the case record for 7 weeks. She did not speculate about intent. She did not use charged language. She simply laid out the sequence, clearly, so that there was no room for misunderstanding about what had occurred. Then she said the words that changed everything. She stated that she was referring the matter to the State Bar's Office of Disciplinary Counsel for investigation into potential violation of the rules of professional conduct, specifically the rule that prohibits an attorney from making false statements of fact to a tribunal. She then addressed the case itself. Given the documented timeline now clearly established by Exhibit 47, the court's assessment of Meridian's central argument had to be revisited. She was not ruling in that moment. She made that clear. But she was placing on the record that the evidentiary foundation of Meridian's timeline defense had been materially undermined. For Daniel Osei, the road ahead was still long. These things are never resolved in a single moment. But the direction had changed. The ground had shifted in a way that no amount of courtroom maneuver could shift back. For Gerald Ashford, The path forward looked very different than it had that morning. The state bar investigation was opened. It took several months, as these processes do. During that time, Ashford continued to practice, continued to maintain a professional posture in public. But within the legal community, word travels with a speed that formal process can't match. There were clients who quietly made other arrangements. There were referrals that stopped coming. There were conversations at firm events that paused when he entered a room. The investigation ultimately substantiated the finding. The formal language of the disciplinary proceeding documented that Ashford had made a misrepresentation of material fact to the court, and that the misrepresentation had been made at a point where he was in possession of, or had access to, the document that contradicted his statement. That last part is crucial. In law, there's a difference between not knowing something and knowing it and saying otherwise. The evidence suggested the latter. His license was suspended, 18 months, with conditions on reinstatement, for a man who had practiced for 22 years, who had built an identity entirely around being the lawyer in the room, who had positioned himself as the person others called when the stakes were highest. This was not just a professional consequence. It was the dismantling of a self-image that had been decades in construction. People in his firm who later spoke about that period described a man who seemed, for the first time, genuinely caught off guard by reality, not by the exposure that, on some level, he had likely known was always a possibility, but by the experience of consequences, of something happening that he could not argue, redirect, or negotiate his way out of. That might seem like a small thing. It isn't. When someone has operated in a certain way for long enough, when enough exceptions have been made, when enough things have been glossed over, when the structure around you has absorbed enough of your behavior without pushing back, you stop building in the assumption of consequence. You start to believe that the rules are for other people, that your skill, your position, your history gives you a kind of exemption. Gerald Ashford had believed on some level that he had earned an exemption. He hadn't. No one does. The Meridian case eventually resolved. The details are protected, but sources familiar with the settlement described it as significantly more favorable to Daniel Osei than anyone at Meridian had anticipated when they first retained Ashford. The evidentiary record that his lie had tried to erase became the foundation of a process that ultimately recognized Osei's contribution. Osei, in a brief statement reported by a local publication, said something that stayed with me. He said he had not gone into that courtroom expecting justice. He had gone in expecting a fight. And what surprised him most was not that he had been believed, but that the system, on that particular day, had worked the way it was supposed to. That's not a small thing to say. It's not a romantic thing to say. It's the statement of someone who has lived long enough to know how often the system doesn't work, and who is therefore quietly astonished when it does. There is something worth sitting with in what this case reveals about the nature of professional deception in high-stakes environments. Ashford was not unintelligent. He was not careless. He was, by most objective measures, exceptionally competent in his field. The mistake he made was not born of ignorance. It was born of impunity. Impunity is what happens when competence goes unchecked for too long. When a person is smart enough to get away with things repeatedly, they begin to confuse getting away with being safe. They start to mistake the absence of consequence for the impossibility of consequence. And in that space, the risk calculation changes. Things that a more cautious person would never attempt start to feel reasonable, manageable, survivable. The document he lied about was not hidden. It was in the discovery record. It had been logged. Any opposing counsel paying close enough attention could find it. And Sadie Carpenter had paid exactly that attention. This is also worth noting, because in a story like this, it's easy to center only the fall of the powerful. But the reason the truth survived in that courtroom was because a younger, less prominent lawyer did the work. She read everything. She built her case around the evidence that was there, not the narrative that was convenient. She waited for the right moment. She was patient and precise. And when the moment came, she was ready. That's not a small thing either. Justice doesn't just happen because it's supposed to. It happens because someone, somewhere, decides it matters enough to do the exhausting, detail-oriented, unglamorous work of being thorough. Of reading page 47 when most people stopped at 15. Of knowing that what looks buried is sometimes the most important thing in the room. There is a version of this story where Osei walks away with nothing, where the document stays buried, where Ashford's reputation holds, and his client wins, and life continues, as it has always continued for people with fewer resources and fewer connections, quietly, unfairly, without resolution. That version happens. It happens more than we like to admit, but it didn't happen here. And understanding why it didn't is as important as understanding what did. It didn't happen because one document survived, because one lawyer read carefully, because one judge paid attention, because the architecture of accountability, imperfect, slow, sometimes cruelly inadequate as it is, held in this particular instance. When Gerald Ashford looked across that courtroom and made his statement, he believed he was in control of the room. He believed, as he had perhaps always believed, that his presence, his authority, his history were enough to determine the outcome. He was wrong. The document didn't care about his reputation. It had been sitting in that record for 7 weeks, patient and unchanged, entirely indifferent to the performance happening around it. A timestamp doesn't adjust itself for a powerful speaker. A filing date doesn't negotiate. The evidence was simply there, waiting for the moment when someone would bring it into the light. That is what makes this story more than a cautionary tale about one man's downfall. It is a story about what accountability actually requires. Not a perfect system, not a guaranteed outcome, but the presence of people willing to do the work, to read carefully, to wait strategically, to speak precisely at the right moment, and institutions that, at least sometimes, respond to honesty over performance. Daniel Osei went into that courtroom carrying 30 years of careful, honest work. He went in as the less powerful party in a dispute with a well-funded opponent and one of the most experienced litigators in the district. He had no guarantee of outcome. He had only the work he had actually done and the documentation that proved it. In the end, that was enough. Not because justice is always guaranteed, but because, on that day, in that room, the truth was in the record, and no amount of confident delivery, no carefully constructed argument, no reputation built across decades could change what was already on page 47 of the discovery filing. A single document, already there, already logged, already waiting. And when it was finally placed in front of the judge, it did exactly what evidence is supposed to do when it meets a lie. It ended it.